Hello everyone, and welcome to this webinar. Thanks to those of you joining from over the pond in the US. I know it's early, and welcome to everyone from Europe and Asia Pacific too. This is the first in a series of 3 webinars that we're going to be running relating to navigating labour, employment and executive compensation issues as part of global M&A transactions. And whilst every M&A transaction is different, especially from a people perspective, those people aspects are often complex and nuanced. And it's hopefully some of those nuances we're going to be covering today. The first half of our webinar will focus on due diligence issues, and then the second half on deal dynamics. And whilst we could probably run a whole day seminar on these subjects, we're going to be trying to keep it within the hour today. So we're only going to be covering things at a high level and the key things that we think you should be aware of. So please let me introduce the panel of speakers joining me today. We have Candace Quinn joining us from Buchanan in New York. Candace is a shareholder at Buchanan and brings a wealth of experience on executive comp and employee benefits from a US and international perspective. Candace's colleague, Antkowiak, is also joining us. Christian is also a shareholder and co-chairs the Buchanan's Labour, Employment, Benefits and Immigration section. So again, has extensive experience from a labour and employment perspective in the US and working cross-jurisdictional with partner firms too. Joining me here in the UK is my colleague Liz Hunter. Liz is a partner at Mishcon de Reya and a part of the remuneration and incentives team. And Liz specialises in advising clients on all forms of share plan, equity incentive and employee ownership arrangements. My name is Dom Wrench. I'm a member of MDR ONE. We're one of the group businesses here at Mishcon de Reya, and we focus solely on international employment law. I work extensively on M&A deals, everything from single country acquisitions to kind of global M&A with people all over the world. So let's get started. I promise you will hear from the other speakers, but I'm going to kick things off today by flagging the key DD issues that we see and think clients should be alive to from an international employment perspective. The first issue is works councils, collective bargaining agreements, and there's kind of a twofold consideration here. The first is to understand what kind of approvals may be required for the transaction itself, or whether there's any information and consultation rights that may relate to the transaction, both from a buy side and a sell side. And one of the key considerations there is normally where the stock as part of the M&A is actually being traded, sometimes where the stock is being sold higher up the chain at kind of a US topco level, then some of the local obligations in Europe in particular can be avoided. But it's certainly worth going through that process to understand where those kind of issues might lie. And the second reason for being aware of this, especially from a buyer's perspective, it's so they know what they're getting, in terms of works councils, such that any kind of post-close harmonization and integration activities can be considered, and especially the timelines for those can be built in. And the same goes for kind of collective bargaining agreements. These can certainly restrict planned actions in terms of pre-close restructuring and also post-close actions too. I've seen a union agreement in Korea where the employees had to be informed about the transaction itself before anything was signed. So it's certainly something to be alive to. Secondly, from an employee census and red flags perspective, from our kind of perspective here, we're looking at 2 things. One, anomalies, and secondly, anything that can create liability. I think with an employee census, it's a bit of a spot the difference type activity, and seeing where you can find those anomalies. So things like, significant salaries, bonuses linked to whole company performance, sales for total sales of the company, that kind of thing. So aspects that might post-close actually create some liability. And this also covers things like accrued leave or significant overtime and working time issues that you should be alive to as part of the deal. And one thing the census also flags as well is that employee versus contractor type difference. And I don't think I've come across a deal yet where there isn't some kind of a misclassification issue that can arise. And sometimes the first port of call when you actually find that out is part of the census. Individual agreements, again, we're looking for 2 things generally, something that will impact the transaction or how the buyer might want to run the company after the close. So, things like specific severance agreements for individuals or severance agreements that cover whole countries that might be far more significant than statutory minimums. Also things like transaction-related bonuses. I've seen a clause in a contract before where an individual received a percentage of the purchase price, and whilst that was a debt item for the seller, it actually impacted the bottom line. So it's important to see where there might be specific agreements that have some kind of nuanced terms. And also, again, from a buyer perspective, you want to know what you're getting. So are there post-termination restrictions, confidentiality agreements, that kind of thing? Things that go to core business protections that you want to be aware of and are in place, or if they're not in place, have a plan to rectify. In terms of benefit and pension plans, it's the same kind of thing that we're looking out for. Anything that creates liability or the running of the company after closing. Pensions is really one of the largest risk areas that we look into. A black hole in an underfunded pension or something that's going to create material liability is certainly something as a buyer that we want to be aware of. And also in terms of benefits, the extent to which benefits are provided over and above statutory minimums, whether they're contractual, non-contractual benefits. And because this really goes to the HR and the post-close, because you want to know whether you're going to be running a two-tier workforce with one set of benefits with the employees you already have, and whether these new employees have something wildly different. Claims and litigation, again, I think it's important to be aware of what's ongoing. So look at what's actual, pending or threatened in terms of litigation, the scope of that liability, what approach has been taken to date on that matter. But also a significant part of our job is to try and uncover issues that might be bubbling away below the surface, that might come to the surface as part of the M&A. It's not uncommon in some deals for employees to be disgruntled in this scenario, or at least a bit shaken by what's going on. And some issues that have been there and underlying can actually come to the surface, as I said. So it's important to understand what might be there, and whilst the risk hasn't actually materialized yet, to be forward-looking of whether it could in the future. And my final point here, just on immigration, I think it's always an important one to consider, because you've got the business continuity aspect. As part of the M&A, does everyone have the right visas, sponsors of those visas, and work permits to be able to continue on day one? But also, there's a real human element here. Whether this is going to impact people's ability to live and work in the country where they are currently. And as we all know, the immigration timeline of authorities isn't going to go to our M&A timeline. And the last thing we want is the deal team calling us the night before closing saying, hey, you haven't got the right visa for someone in Timbuktu, and we need to get that sorted. So that's why immigration and work visas is always something to be alive to and be aware of. And on that point, I'm going to hand over to Liz.
Thanks, Dominic. So now we're going to think about the share plans, the incentive side of DD. Dom talked about employee census, so let's start with that as a data point. We don't see often enough segmentation of data showing country by country analysis, nor do we always see identification of who are the employees, who are the non-execs, who are the consultants and contractors, and who are those people who are working cross-border or are internationally mobile. That's a really key starting point in terms of data analysis, and it will impact what documents need to be reviewed by whom, what's relevant, what's not relevant. We also need to understand actually the nature of the transaction. Is this a minority investment? If so, perhaps lighter touch DD, less likely to trigger an exercise of stock options, for example, as opposed to a change of control event. But beware what might start off looking like a minority investment, but which, perhaps due to certain regulatory aspects like the UK Takeover Code, might end up triggering a requirement for a change of control if certain investment thresholds are met. So the importance of employees versus non-employees, and let's throw in this new worker status that comes with employer of record and PEO structures as well. That's important to identify because it's going to require interrogation in terms of the legal diligence, the securities laws compliance, and the tax treatment. So let's think about securities laws first and foremost. If you've got awards made under an employee share plan and those are being made to directors or employees, that's probably all fine. But if you've got awards made to consultants, contractors, then certain jurisdictions are going to actually have a complete prohibition against that. India, for example, if you've got a private company and you've got awards made to contractors in that jurisdiction, that's a breach of their securities laws. In other countries, let's look at the UK. Well, are the individual recipients high net worth individuals or sophisticated investors as defined under the Financial Promotions Order, a regime that's under consultation and has already had some yo-yoing and flux of definition this year? If you're looking into the EU, you might be fine under the EU prospectus regime if the awards are to less than 150 employees or consultants, but it's not applied on a consistent basis, so you can't assume that that's a tick box exercise. On the tax side of things, well, to understand the treatment, we'll need to have a look at all the documents, and we'll also need to look at the documents to check the legal compliance. Accessing the documents in a data room should be a fairly fundamental position. However, we're aware many employers now use tech-enabled solutions for hosting their share plan data and documents. Not all of those will allow you to export the full plan award agreements. So checking what's available, can you access it readily? Is it exportable? Is kind of in that transaction readiness bucket we mentioned earlier. In terms of the tax and social security, most countries now, if you've got employment-related awards, will require employer reporting and employer withholding, but not all. So, for example, Portugal does not require employer withholding, but you need to be ready to apply it anyway, because the employees have a right to ask the employer to withhold. In most jurisdictions, we might expect the tax point to be at exercise of a share option. Usually that's the case. But take Belgium, for example. There, the tax point can actually be at grant, depending on whether the option's been accepted within or outside an initial 60-day period. In Singapore, there's no withholding tax required, but there are exit charges if someone leaves and stops working in Singapore. There's a deemed gain that arises for the employee that's departing, and additional employer reporting required. So for those internationally mobile employees that have perhaps moved from Singapore to another country during the life of an award, has that been dealt with correctly or not? For DD, we look backwards to look at those historic risks, but we're also going to be looking forward at what unfunded, unplanned, unexpected liabilities might arise on closing of the transaction. And there's some practicalities there around those internationally mobile employees. Can you track their work days? Is there visibility of how long they have spent in each country to source and apply the correct withholding? And leavers. Leavers are the headache. You think you're being benevolent to your good leavers, but where are they now? Do you have powers of attorney in place? Have they geographically triggered liabilities in other countries you're not aware of? And who's going to be departing? What's your treatment going to be through the transaction? How are you actually retaining your key talent? So that's a starter for 10 on the share plan, DD. I'll now hand over to the Buchanan team for the US lens on this.
Well, thanks, Liz, and thanks, Dominic. Appreciate your partnership on this. You all have been great to work with, and your knowledge in this area is extensive, and it's been fantastic. So I would encourage all those on this webinar, if you have international issues, certainly to reach out to the Mishcon team. As Liz said, I'm going to talk a little bit about the U.S. Employment issues as they relate to matters of due diligence. You know, we could certainly spend a full hour on any one of the topics. You know, I too am going to hit the handful of items at a high level. These are by far not, you know, every item we look at in due diligence, but I selected these because they not only are they important, but I think that, you know, if you have a business in the US, these are also things that you should be looking at now, not just from a due diligence standpoint, from a compliance and litigation standpoint, because we often see litigation arising out of these particular areas right now as we look to things like statistics, whether it's EEOC enforcement or trends in litigation. And so the first of those is wage and hour and pay equity. Dawn mentioned misclassification issues. They are by far and above my top concern when I work on due diligence projects. There are two types of misclassification in the United States. Dawn mentioned one that's similar, I think, to Europe and other jurisdictions. That's the misclassification of employees as independent contractors. But there is another type in the US that's very specific to our jurisdiction, and that's incorrectly classifying employees as exempt from overtime and from certain minimum wage rules. And by that, I mean in the US, there's a law called the Fair Labor Standards Act that dictates employees that work over 40 hours in a week are entitled to additional pay unless they meet a certain exemption. Well, recently, the Department of Labor promulgated new rules that raise the requirements to meet that exemption from overtime. The second of those increases will soon go into effect in January. And what that means is for a worker to be exempt from overtime, they're going to have to make at least $58,656 per year, in addition to meeting certain duties tests. We have found in due diligence that employers are often misclassifying workers, either because they don't understand the salary thresholds or perhaps the duties tests that accompany that. We think the issue will be more acute as we go forward because not many companies are prepared for these salary changes, many of them thinking correctly that they will not go into effect because of court challenges facing the Department of Labor's authority. But in due diligence, you really need to look out for those. And for my colleagues on the webinar that are going to 2025 and in-house counsel, they need to be looking at that in their own company to make sure that they're compliant moving forward. One of the other issues in due diligence, the treatment of certain bonus pay and whether or not that factors into overtime compensation is something we always look at. And of course, pay equity. Right now in the United States, there are several states, including places like Colorado, California, New York, and Washington, that have pay transparency laws requiring employers to post wage ranges. And those lists of states are growing. These laws are intended to increase pay equity. They are, along with something called the Equal Pay Act, being enforced in many jurisdictions across the country. Litigation is increasing in that space. And so when conducting M&A due diligence, I think it's important to assess the target company's compliance with these pay transparency laws and the Equal Pay Act. If you don't, there's a pretty good chance that you will inherit or acquire significant litigation going forward. One of the next areas, of course, union successorship and organizing campaigns. Dominic talked a little bit previously about the importance of discovering union-related issues. You know, in the US, when a company purchases the assets of a unionized employer with certain caveats, the asset purchaser is deemed a successor. That may come as a surprise to some people because you're just purchasing the assets. You wouldn't necessarily think that you necessarily acquire some of those union and labor obligations. You need to take very specific steps to limit your exposure in this space. And so appreciating what you are acquiring from a union standpoint is necessary. And we'll talk a little bit about what you can do in terms of deal terms to minimize your risk in this space going forward, sort of in the next segment. But looking closely at union successorship and organizing campaigns and other potential liabilities is always something we look very closely at. Discrimination claims are the next big bucket. There are a multitude of federal and state anti-discrimination laws in the United States that are driving significant litigation at the moment. And you must understand that as part of the due diligence process. Just to give you some quick statistics, the Equal Employment Opportunity Commission in the US is an agency that collects the first stage of employee complaints of discrimination under federal law. There was a 10% increase year over year in the number of charges filed with that agency. And that agency secured $665 million in monetary relief for employment discrimination, a 29% increase year over year. That's important because when you're doing due diligence, you want to understand, I think, where the agency's priorities are and try to ferret out the potential risk that might face you as the acquiring entity when you're looking at a company's practices and their policies. And one of the areas in which the EEOC has made a strategic priority from 2024 to 2028 is eliminating barriers in recruiting and hiring. And in particular, they're looking at a company's use of criminal records and hiring decisions and the use of artificial intelligence in hiring to potentially screen out and create adverse impact on groups of individuals who are in protected categories. And so when we're doing due diligence, we're looking closely, not just at things like, how many pieces of litigation has the company had or what's their historical trend been. Those are certainly important things. But as Dom said, trying to figure out where the next issue is coming from, what's bubbling under the surface. Right now, I think it behooves companies to know and appreciate where the EEOC's strategic enforcement initiatives are and to use that to inform their due diligence efforts. One of the next areas I'll just touch on briefly is OSHA. It's not something that gets talked about a lot, but keeping an eye on OSHA violations is always important, I think, during due diligence, and it's especially crucial now. So OSHA is the Occupational Safety and Health Administration in the US, and there is a provision called the General Duties Clause. And under OSHA law, that clause requires employers to provide a workplace free from certain hazards that cause death or serious harm. And OSHA views the failure to have a written COVID policy, for example, distributed to employees as a violation of this clause. So during due diligence, I think it's incredibly important to look at the workplace safety issues and understand the policies, practices, claims, and culture that that company has in order to minimize potential risk as you acquired the entity. And the last item I just want to mention, the Fair Credit Reporting Act and background checks. I think this is an often overlooked but critical area of M&A due diligence. So the FCRA sets guidelines for how employers in the US can obtain and use background checks from third-party sources. Employers have to follow specific steps at various points in the process. So, for example, before requesting a background check, before taking any negative action based on it, and after taking action. On top of the federal requirements, if you haven't noticed the theme, there are many states in the United States that have their own laws governing these background checks. And appreciating the interplay of those laws and those requirements is going to be absolutely necessary in due diligence to mitigate risk going forward. So with those items in mind, I'm going to turn it over to Candace Quinn to talk about some of the benefits issues.
Wonderful. Thank you so much, Christian. In M&A due diligence issues and employee benefits, I'm going to follow in Christian's framework. First, sellers in these areas are primarily focused on, one, ensuring that the representations it will make in their purchase agreement are accurate. Second, that the employee plan inventory lists are comprehensive. And last, and mitigating any possibility that the pension plans, the executive compensation agreements, or other employee benefit terms or compliance issues do not impact the viability of the transaction in the deal terms. Now, buyers are primarily focused on assessing risks and quantifying potential liabilities and costs, and determining if there are red flag issues that could impact the viability of the deal or change the amount that's going to be paid. Now, employee benefit retirement plans and executive agreements can present red flag issues and can contribute to potential costs and even impact the price the buyer is willing to pay, and in extreme cases, can add to the reasons the buyer may lose interest. Now, initially, I like to look at who are the parties to the transaction. Are either party publicly listed companies in the US or abroad? Is the seller a multinational company? Are they part of a controlled group? Does the seller have ERISA affiliates, as this can impact the application of certain US compensation and benefits laws? And then the type of business of the seller and the buyer. This can trigger other M&A issues. And then to look at determining what is the stage of the transaction. Now, pre-closing, which we're discussing today, again, the buyer focuses on conducting due diligence, reviewing the seller's representation, and assessing potential liability and financial risk. In later sessions, as Dawn mentioned, we'll talk about closing issues, post-closing cleanup. Now, the type of transaction with regard to employee benefits is important. Is the buyer buying the equity or the stock of the company, or they're just looking at the assets? This can impact the areas of potential liability for a buyer. Even if it's an asset sale, there might be successor liability for certain matters, as Christian mentioned. And what will be the insurance? Will it be representation and warranty insurance in this deal? Well, if the buyer purchases R&W insurance, that could lessen potential liability to risk to some extent. Okay, now let's look at specific plans and types of agreements that require careful review and that could result in significant liability or risk to a potential buyer. In the US, we have qualified retirement plans, and they must comply with strict statutory requirements, both under the Employee Retirement and Retirement Income and Security Act, also known as ERISA, and the Internal Revenue Code. If they meet these requirements, then the contributions to the plan for the employees are not taxable currently by the employees, and the employer is entitled to a tax compensation deduction. So whether it's a defined benefit plan or a defined contribution plan under a 401k, it's very important to carefully review the plan documents in terms of liabilities and potential risks. It is also important to review the seller's representation with regard to the qualified status of these plans. Can the plans be amended or terminated, or whether the operation of the plan is complying with the plan terms? Has the funding been satisfied? As Dawn mentions, pensions can be a black hole. It's no different in the US. Potentially very significant liability in this area. And then also you're looking at the seller's representations to determine, have the Internal Revenue Code and ERISA statutory requirements been complied with? Have they filed timely 5500s? Are there any prohibited transactions, any IRS and DOL audits? Has the seller filed a voluntary correction application with the IRS seeking amnesty for compliance issues or correction? If the plan blows up due to failure to comply with ERISA or the Internal Revenue Code, this can be significant liability for a company and the employees. The next area of types of plans is incentive plans and awards. Now, there are many different types of incentive plans to attract, retain, and incentivize executives. There are stock options, there are incentive stock options or ISOs, there are restricted stock units or RSUs, and there are also phantom stock appreciation rights or SARs. Now, it's very important that the seller's representations should be addressing the qualification and the compliance with regard to all these types of plans, and whether Section 83B elections are timely filed, and if there's any 409A issues. Now, these plans should be listed in inventory and the data room, and Liz brought up a good point. Let's hope they're provided in the data room, can be provided in the data room. In a multinational transaction, it is not unusual for incentive plans to refer back to the foreign parent company, especially if there's grants of foreign parent company stock or foreign company stock options, as Liz and I have seen in past transactions. Now, a key term in incentive plans is change of control. Again, this is something that sounds to be a universal concern and issue. And in this area, you're looking to see if there's an accelerated innovation of vesting of an award due to a change of control, such as a merger and acquisition, where over 50% of the company's stock or assets could change. Another area is deferred compensation agreements, cash incentive bonuses, and executive agreements. All of these should be addressed in the seller's representation. Now, severance pay plans should be reviewed and to see if they provide for triggering, if there is an M&A and a termination. Now, the deal section, I'm going to go over what significance of some of these payments that will be triggered on a change of control. because they have significant impact on tax potential penalties under Section 280G of the Internal Revenue Code, the parachute payment penalties. Now, health and care and welfare plans. The seller's representation should be addressing ERISA and Internal Revenue Code compliance with regard to these plans, and they should be providing the plans in their inventory and in the data room. Now, it's very important that the buyer reviews to see what types of plan has adopted, especially if they're buying the company, the compliance status of the plans, any claims litigation, any IRS or DOL audits, compliance with COBRA and the Affordable Care Act. Now, as you can see, review of these plans is clearly, and this section is clearly focused on determining if there are red flag issues. And in the deal issue, we're going to be looking at quantifying these potential liabilities. Now, as Kristen mentioned in the beginning, this level of due diligence practice is very important. It's important long before there's a deal on the table. It's important to make sure your plans are in compliance so that you can address it. So down the road, when there is a deal, you will not have an issue as a seller for what your plans should be in compliance with. Now, with that, I want to thank you and turn it back to Dom.
Thanks, Candace. What I really liked about that first section is the fact that the similar kind of issues arise globally, right? We're talking about the same kind of things, but it's the country nuance, which is so important to nail down on, because where something might be a risk in one country, to some extent, in other countries, it's much more significant. And I really like to see that interplay. We're now going to switch it over to the second half of the webinar, where we're going to talk a bit more about deal dynamics and the impact of where that due diligence then moves forward through the life cycle of the transaction. So again, I'm going to be touching on the employment deal issues that we kind of see from a UK and international perspective. So firstly, the transaction agreement itself, it's vital that we see that and input into that from an employment perspective. I know the deal lawyers like to keep it to themselves as much as they can and don't love our drafting, but we need to see it. From an employment perspective, there's probably 3 or 4 areas that we tend to typically input on. The first is the reps and warranties that Candace has spoken about as well. They're vital to understanding the liability between the companies and also applying what you've seen in due diligence, not just having boilerplate reps and warranties that could go in any transaction agreement, making sure they're actually tailored to what we've seen. The second is employment covenants and actions. I mean, these are pretty broad ranging. I've seen everything from this deal won't go ahead until X number of employees have signed a new contract to, buyer has to keep the same material terms and conditions in place for 12 months after closing. So again, it has to be tailored to the deal and what's actually been agreed commercially between the parties. The third area is interim operating covenants. So, what the seller can do between sign and close with the company. Sometimes this period is long, especially if there's regulatory approvals. And whilst the seller needs to run business as usual, there's certain things as a buyer that we would want to ensure we're at least aware of or have some input on, such that there aren't significant restructurings or rifts or material employment contracts being entered into. So that has to be fairly carefully drafted. And then the final point is the indemnities and liabilities for a number of the issues that we've spoken about at the diligence stage and where they need to be accounted for in the agreement. And also back to my original works council point as well, where there may be approvals needed, we need to make sure that they're built into the transaction agreement as well, and their timings are considered as part of that. The second point, transfer mechanisms, and this goes back to again, what Candace mentioned. I think our number one question is normally, okay, is it a share purchase? Is it an asset purchase? Because everything else kind of flows from that direct starting point. Where it's a share purchase, generally, it's a bit more straightforward. You're getting the lot. And obviously there are some nuances around that, but that's the kind of a rough starting point, unless there's any pre-close restructuring as well. So whilst the actual transaction itself may be a share purchase, we need to think about what's going on before it as well, and whether there needs to be any employee transfers as part of that. And if there are going to be transfers, we have to consider, where there's different automatic transfer provisions under law, or where we need to be doing something a bit more formal or manual with the employees. And then that goes to the same point as if it's an asset transaction as well, and we're carving certain pieces out of a business. The transfer mechanism point is really important to understand legally what's going to happen, and then ensuring again that the transaction document reflects that and the liability associated with those transfers. I'm going to just move it on to the orphaned employees point. And whilst this term I actually really dislike, it keeps coming up and I can't seem to get it to go away. So I've run with it here. And we're talking about employees in countries potentially not within scope of the transaction, but perhaps provide their services fully to the business and then the target that does want to be acquired. And so we need to be thinking about how we bring them into the scope of the transaction. And whether that's something that happens pre-closing and then they're bought as a package, or whether there needs to be something that happens post-closing, and then actually how we're going to do that. You know, in different countries, we need to take a different approach. So there may need to be some firing and rehiring, or there may need to be a more mutual kind of tripartite approach or something to that effect. So this is just a really interesting point to, again, make sure that what the buyer wants to go and what the seller wants to go does go as part of the deal. And there aren't ones and twos that we have to deal with after where we can help it. And again, from my perspective as well, you know, the last thing you want is the deal lawyers calling you on the day of closing saying, you know, why is person X in Timbuktu non-transferring? We're not signing and we're not closing until it goes ahead. And you don't want to be on the receiving end of those calls, that's for sure. And the same point, again, is similar to PEO employees. Apart from there, we've got a third party involved as well. And that just adds another layer of complexity. So where a seller may have, you know, a salesperson based in one country, two in another, they might not have their own entity, so they utilize the PEO model. And again, we need to be considering notice periods with the PEO. And I don't mean employment notice periods. I mean what's been agreed commercially, but between the company engaging them and the PEO for them to release their services. And again, if those timelines don't fit into deal times, then we need to work through a solution there. So it's important, I think, especially with the PEO employees, to be considering that piece as soon as we can and making sure that, again, nothing gets held up from that perspective. And then my final point here, relating to the deal timing is, you know, the extent to which all of the above things we've talked about are considered and built into timelines and documented where needed to be in the transaction agreement. I think it's really important that we're all aware of where employment actions need to be taken and where they fall into line with those. And then just as a kind of a final point from me in terms of the deal issues, I think one thing that does always help from my perspective is when HR teams are involved in the deal and kind of not just left to the last minute and given a whole bunch of information in terms of workforces that they're inheriting or in fact getting rid of it at the last stage. It's important where possible, obviously, for confidentiality and things like that, for them to be under the hood and be aware of what's going on and actually help input into the deal, because ultimately some of their, you know, the decisions are with them and in how the workforce will operate. And so it's important that they can input into the deal where they can. And so that's it from me on that. So back over to Liz.
Thanks, Dominic. So deal issues, share plans, reward matters. Did Candace throw enough acronyms at you? I could add a whole load more because, you know, trying to understand what happens with different types of stock arrangements globally is difficult. We call the same thing by different names sometimes. Something that is tax advantage in one jurisdiction, rolled out globally, does not translate as well abroad at all. Throw in, you've got an employer genuinely trying to embrace employee ownership and participation. So scattering these awards very widely across an organization. And there can sometimes be just a bit of a scratching of the head by some of the transaction lawyers. Are we really going to have all these sellers on the SPA to deal with? Can we just, I know, an administrative easement, let's just cash cancel them. They're going to get cash, they'll be happy. Well, what tax liabilities is that going to throw up compared with keeping them as shareholders in the deal? If you've got qualifying plans in France or tax advantage arrangements in the UK, those tax advantages are worth keeping, even if it requires a little bit more effort in the papering of the transaction, and ensuring you've got powers of attorney in place for all these additional sellers in the process. Uniquely, perhaps in the UK, one of the biggest liability red flag matters can be the employer social security. Okay, what's unique about that? That applies everywhere, right? Well, what's unique is in the UK, that liability can sometimes be passed on to the option plan recipient. So the employee, you've got to have particular terms in the agreement right from the start, but reviewing those to see if that's in place can be key. So an option arrangement that's tax advantage is going to deliver perhaps corporation tax savings for the employer. That employer social security liability that's often a red flag matter may not be a red flag issue at all, because it may actually sit with the employee. If you cash cancel that award, you might lose all of those favourable treatment aspects. So an administrative easement, sometimes yes, sometimes no. So thinking about it in the round. Other practical matters, transaction timeline. Well, what if the due diligence has thrown up some question marks around treatment? In some jurisdictions, you might be able to go to the local tax authority and get clearance or a ruling to get certainty as to what treatment should be applied. Is there time? Not always. These things sometimes come out at the 11th hour. There is not going to be time to make a submission, wait for a response, which may just be more questions, and negotiating and seeking clarity from the tax authority. Sometimes that will only come after closing. So perhaps you need to think about escrow arrangements and build that into the process as well. Are there going to be any awards made before closing? That can be a challenge sometimes if you've already got commitment for a change of control, which is more likely than not to take place. You may not be able to qualify for some tax advantage arrangements. What if those last-minute top-up awards are too generous? How are those individuals going to be retained post-deal, or are they walking away in the sunset with a whole heap of cash, no longer interested in pursuing their role in this new owned business? So, is there too much cash in the deal? Do they need to have some of their equity rewards rolled over into stock in the buyer, and with some retention and stickiness post-closing to keep them performing and managing continuity of commercial business performance through that transition process? Is there not enough cash in the deal to let them pay their exercise prices, their tax, the social security? So this financial model should be well tested and formed through this stage of the process. Follow the money is not a bad mantra, and it applies here too. The fund flow, does it work? Does it throw up any dry tax issues that need to be solved for? Are there going to be loans put in place between employer and employee? And what are any regulatory aspects around that from a legal perspective? And what's any other iteration of tax position from a tax and reporting aspect? One thing that I would highlight, because it's put the cat among the pigeons a bit, so to speak, in the UK, is a recent case, Ponticelli and Gallagher. Now, that was the case where an employee was 2P'd over as part of a transaction. Prior to the closing of that deal, they had participated in a tax advantage arrangement, buying shares from money saved from salary each month. Post the transaction, the structure of the new buyer could not operate that same arrangement, and actually there wasn't appetite to do so, but they were given a cash compensation payment in lieu of that award of equity. The Employment Tribunal held that wasn't good enough, and actually there should have been a substantially equivalent equity arrangement put in place by buyer. There's no clarity on what substantially equivalent means, and as was the case there, buyers aren't always going to be eligible to operate identical tax advantage arrangements, qualifying structures in different jurisdictions. So where does that leave us? It's a point you're going to need to think about more and more on transactions. So what does the new post-closing equity offer need to look like? Needs to be thought about as much as what's already there here and now. And in that vein, thinking about earnouts in trade sales, often there will be an element of the consideration that's held back, it's paid over time based on future business performance. That's not necessarily going to get capital treatment for the sellers. Do they care? Again, this comes down to what are their expectations? What are their must-haves and red lines? What's the tax treatment on a country-by-country basis? Corporation tax deductions can be very valuable negotiating aspects in a transaction. They're cash-like item in the transaction fund flow. And who's going to get the benefit of that? Is it buyer or seller? Can it be negotiated in any way? Has it been compromised? Is it available? So looking at that on a country-by-country basis, sometimes that means looking at, are there recharge arrangements in place or not? Who's bearing the economic cost of the provision of these awards? And what's the fact pattern and local country statutory position? Now, thinking about our US participants, I'm going to hand over to Buchanan, but before I do, I'm just going to give that reminder that US issues do not only apply within the territorial states of the US, your US citizens, your green card holders worldwide need to be looked at through this lens, and that often catches people out. People say, no, everyone's in the UK. Okay, is anyone in the UK a US citizen? If so, you need to know about Candace. Now we're going to talk to you about. Christian, also, over to you.
Yeah, thanks, Liz. You make a really good point there. And before you, Dominic, as well, you know, when we're talking about how remarkably similar these deal dynamics can be cross-border, that's absolutely true. And at least on the employment side, I think, you know, Dom covered a number of the topics at a high level that I think the points he made are equally applicable to the United States. And so what I'd like to do in the next 5 or 6 minutes or so is just briefly drill down on a couple of jurisdiction-specific issues here in the United States in a way that I'm being additive to his presentation, maybe, and not duplicative. The first of those is something called the WARN Act. And, you know, in the United States, if you're an employer of a sufficient size and you're conducting layoffs or plant closings, you have to assess whether this act, the Worker Adjustment and Retraining Notification Act, applies. Many states also have a similar, we call them mini WARN Acts here in the US. These are laws that sort of prescribe certain notification to workers, to local government officials. And if you don't abide by the specifics of these laws, if they are triggered, you could have significant liability. In an M&A transaction, it's important to understand that the seller is responsible for these notifications for any layoffs that meet the requirements if they occur before the close of the transaction. And so the buyer is responsible for providing that notice, at least typically, for any layoffs that meet the requirements of the statute that occur after the close of the transaction. I think that's really important to understand because, you know, when you're talking about deal dynamics, if you are bringing over a number of the employees for transition purposes, but maybe separating them as a client of mine did in a recent transaction within the first 60 days post-close, that buyer may assume liability for WARN notification and the failure to provide notification and similar state law requirements. So understanding WARN, what you want to do with employees and that transfer of employees, if there are any, is really critical in terms of how you structure the deal and who may be required to give notice, who may hold the liability in the event of a failure to provide adequate notice, so on and so forth. There's also a way in which you can structure a release from WARN as part of a separation agreement. So if you are concerned about WARN liability, who pays for that, how it's structured, who's giving the release, which parties are included as released parties, all critical aspects of the deal dynamic as well. I won't spend a whole lot of time on reps, warranties, and indemnification. I feel like we've talked about that. to some extent already. Obviously, if you're on the sell side, material compliance with law is something that you are going to rep or warranty. Talking about union organizing activities, demand for union recognition. We talked about proper exemption classifications. It's why we place so much emphasis on putting the important work into compliance ahead of the transaction, because if you're on the sell side, you're going to be making certain representations and you don't want to find yourself in breach later if you failed to disclose. And on the buyer side, it certainly gives folks cold feet if there's a lack of confidence in the seller's work ahead of time to make sure these issues are buttoned up and appropriately represented in the agreement. Restrictive covenants, employers around the world, I think, have long relied on non-competes to protect their investments in things like intellectual property, talent, customer relationships. The main purpose of including them in an M&A transaction, from my perspective, is to safeguard the buyer's value in the business that they purchase. These agreements are common in the U.S. I think there is a perception that based on recent agency activity, maybe they are not enforceable in the United States, but the Federal Trade Commission's attempts to eliminate non-compete has at least for now been placed on hold. And so for the most part, I would say that non-competes are enforceable in the United States, though, there are many jurisdictions in the US where they are prohibited, California being an example. There is a difference in treatment with respect to non-competes when they are made in connection with the sale of a business. And so you do have an opportunity in the deal to perhaps get a greater non-compete in terms of duration or geography than you would if you did a standalone agreement. And so those are really important aspects of the deal to think about and make sure they're papered appropriately when you're putting together employee agreements, which brings us to the next topic. Obviously, retention agreements, change in control, severance. Again, we've talked about this at some length, so I don't want to spend too much time on it, but it's important to make sure that you're understanding who you want to keep, how long do you want to lock them into the agreement, if they're necessary for the continuation of the business, whether it's an asset deal or a stock deal. Those are key considerations. Liz mentioned immigration in the transition. I think that's incredibly important. In the United States, the rules around immigration can be tricky, and oftentimes timing is crucial. Mistakes often include things like accepting the wrong documentation, fraudulent documents, so on and so forth, can become very problematic. And so understanding that in terms of the deal dynamics and making sure those issues are papered correctly are critical. It's especially true if the target company employs foreign nationals on things like visas. For example, non-immigrant visas tied to a specific employer, such as an H-1B, can be affected by corporate mergers and acquisitions. You need to understand those dynamics and make sure they're appropriately documented in the deal in order to maybe carry forward and continue using those workers. The last item I included on the list, it's probably more appropriate for one of the future segments, integration and workforce cultural issues. I put this here because, I saw a recent study by McKinsey showing that 2 leading causes of failed mergers are due to cultural differences and changed operating models. I think it's a common mistake to focus solely on the financial aspects of a deal and not the transaction's impact on employees. Certainly, diligence has a role to play in this, but as you're constructing the deal and you're thinking about deal dynamics and the transfers of employees and the effects of immigration and all of these other aspects, non-compete, you want to make sure you are addressing workforce cultural issues. Otherwise, that could potentially creep up and be something that does ultimately cause the merger to fail. So with that, that concludes my segment, and I will hand it over to Candace to finish us off. Candace?
Thank you so much, Christian. And in this section, with regard to, we've had the due diligence, we've determined that there might be red flag issues. And now we're looking at quantifying potential costs and liabilities. And first we look at the qualified plan area, and we know that compliance is a key concern. And again, we point out, is it an equity deal or a stock deal, to know whether these plans are going to actually go with the buyer or not. And then next, if it's a pension plan that the company has, how is the funding? And also, there are a number of issues right now in the US regarding qualified plans that are under a series of attacks by plaintiffs' lawyers with regard to class action topics, whether it's pension de-risking or fees or many other topics regarding this. So clearly a significant due diligence if the company has these plans and it is going to be an equity buy. With regard to incentive plans, stock option awards, deferred compensation, and executive agreements, one of the key points that I mentioned earlier is with regard to change of control and 409I potential liability. Now, Liz teed up nicely the concern regarding 409A, and I'll deal with that in a minute, but I do want to point out that one of the problems with this type of area is that the executive agreement can provide that there's going to be gross ups for these payments, which can be significant, and this can impact the buyer's costs when it sees what is involved. Because some of these, I've dealt with one executive that had millions of dollars that was at stake, and it was all guaranteed to be grossed up. Another is earnouts. If there's earnouts in the incentive agreement, basing additional compensation on certain hurdles, it's very important to review the terms with regard to those earnouts. And tax risks. Now the star of the tax risk show clearly is 409A, which unless you have a specific exception, deferred compensation that does not satisfy the strict statutory requirement, the recipient is subject to a 20% tax before interest and penalty, and that could mean up to a 70% tax in the US, because not only is there a 20% tax for 409A, the federal income tax can be up to 37%, and the state taxes can even be up to 13%. And then if the resident lives in California, the recipient lives in California, then there's an extra 5% for violating 409A. So you've got a 75% tax for interest and penalties. This is a concern for a buyer that wants to recruit that executive to join his or her team after the acquisition. So 409A is significant. The reach, as Liz mentioned, and it is more than just as to vanilla deferred compensation agreements. It can apply to stock appreciation rights and stock options, whose exercise price is not equal to the fair market value of the underlying stock on the date of the stock grant. Now, in the US, that means that any discounts on fair market value will violate 409A. This is important for transnational transactions because grants of foreign parent company stock to US citizens in the US subsidiaries can't have that discount that was provided in the foreign parent company. It violates 409A. An additional address needs to be taken before that stock is granted. And unless a company is publicly listed, one way to mitigate the potential issues with regard to stock option exercises is an independent fair market valuation of the company's stock. This will give you a protection in an audit, and it's something that the buyer can ask to find out what the seller's procedures were in setting their exercise price. Very important because IRS transfer pricing audits typically couple a review of the stock option exercise price, and this is important for multinational transactions. I've seen it. I've been involved in representing companies that had this issue. Another important issue, and I know our time is limited, almost up, is 409A has a 6-month rule. If the stock is of a public company, whether US or foreign-based, you have to defer the payment to certain people known as specified employees until 6 months after they've left. I can give you more information. Please follow up with me if you want on who is a specified employee. And I also want to discuss 280G just quickly. That's the golden parachute rule. This applies to corporations only, not subchapter S, and all these payments we've been talking about, transaction bonus, severances, accelerated vesting on equity, and 12 months before a change of control, any increases in compensation could all be subject to another 20% tax under 280G, and the executive's company will lose the compensation deduction. Now, parachute payments are very specific. They require a calculation. They should be addressed by the seller in the representation that they provide. It can be mitigated if you're a private company and the shareholders approve more than 75% of the shareholders approve this parachute payments to the executives, and the executive agrees to forgo the payments if they're not approved. And lastly, health and welfare plans. I can't stress enough how important it is that these, especially if this is going to be an equity deal, that the ERISA, Internal Revenue Code, the Affordable Care Act, and other requirements under the US law are complied with. The penalties can be quite high, whether it's a COBRA notice or failure to file a 5500. For instance, $250 a day per return, up to $150,000, and the DOL penalty, $2,586 a day with no maximum. So just to conclude, there are correction programs in the US for all of these. But again, due diligence review prior to the deal being on the table is very important to have these addressed. So as we've seen, ERISA and the Internal Revenue Code presents significant issues in an M&A, and it can lead to significant liability. I highly recommend having an expert in the field both prepare the reviews and conduct the review for the buyer. With that, I thank you, and I turn it back to Dawn for the close.
Yeah, thanks, Candace, and I promise in the next seminar you can go first, so you don't have to go on two times speed at the end. We'll take it in turns. Thanks everyone for joining. It's been a real pleasure, and I hope you found it a useful webinar. Today we've kind of really delved into the heart of the M&A process, and for our next two webinars, we're going to be taking one step backwards towards transaction readiness, and then for the third one, we're going to be going the other direction and looking at post-closing integration and harmonization. So thanks again for joining. Have a great rest of your day, and we look forward to hopefully you joining us in future sessions. Thanks again to all.
Thank you.